He has stepped into the shoes and the body of the tribunal instead of being separate and apart from the tribunal. My Lord, the other mistake or error by this tribunal is owning the witnesses as your own. The witnesses belong to the prosecutor instead of the tribunal. My Lord, the other error is that the lead counsel summoned only inculpatory witnesses and not exculpatory witnesses. Only witnesses that support their case and not witnesses that are against their case. That is not the law. My Lord, material witnesses were mentioned for the meetings of 3 a.m., 2 p.m., 4 p.m. None of them was called before this tribunal. And again, that is the law. You cannot mention someone adversely and not give them a chance to appear before you. My Lord, the other error by this tribunal, and of course led by the lead counsel, is that it can review, revisit, or revise a Supreme Court judgment, and also the other decision of the High Court or Employment Court against Irene Masit in respect of whether she stood in the 2017 elections. What the lead counsel wants you to do is to revisit those two cases, the Supreme Court decision and the Employment Court Tribunal. The other fundamental error of this tribunal, my Lord, is that you've proceeded without articles of impeachment. And then the last one, my Lord, is that this tribunal proceeded or thought it could proceed outside the law of evidence, statutes, and established law. My Lord, when this tribunal was set up by the Gazette Notice 14890, the Gazette Notice itself had that fundamental error. It made the tribunal as one body. The commission members, the joint secretaries, and the lead counsel as one body. My Lord, our impeachment proceedings, of course, has been set out, is in Article 251 of the Constitution. I've set out in extenso in my submission the entire Article 251 of the Constitution. And under Article 248, it sets out the bodies that are under the Article 251, which includes the IEBC. My Lord, the petition before you is, as again set out by Peter, is set out in Volume 1 of the documents before you. The petition was filed in Parliament by the 4 petitioners, and I'm not going to repeat them. But the essence of the 4 petitions that are for the removal from office of IEBC Vice Chairperson Juliana Cherera, Commissioners Francis Wanderi, Irene Masit, and Julius Nyangaya, on account of serious violation of the Constitution, gross misconduct, and gross incompetence, pursuant to Article 251 of the Constitution. My Lord, for us to understand impeachment proceedings and trial, we must go back again in history. The first impeachment in history was of William Latimer in England in 1376. And it's from that impeachment trial that all other impeachments are followed. What lead counsel wants you to do is to reinvent the wheel. The impeachment proceedings in this country, just like in USA, South Africa, India, Malawi, Nigeria, and any other country that follows the English common law and the Anglo-Saxon law, is the same. The foundation was laid in 14th century. In one of the articles that I've annexed, a scholarly article, Professor Charles Morgan says, under our Constitution and in the British system from which it is derived, impeachment was designed to control the excesses of the executive in England. In England, it was the primary tool in the democratic struggle to bring ministers of the king within the sanction of the law. Impeachment, thus, in its foundation, my Lord, was a political tool using criminal process to rein in the ministers of the king. One of the leading impeachment trials, again, my Lord and members, was the trial of Warren Hastings, which took place from 1787 to 1795 in England. Because the case was cause célèbre, it's the one again that continued to develop the law relating to impeachment proceedings and trial. The impeachment of Hastings coincided with the independence struggle in America. The founding fathers of America took that impeachment, the lessons they learned from that, to inbuild in the Constitution impeachment in America. And my Lord, I've set out in scholarly articles again the history of impeachment. And the first one is the historical overview by Professor Charles Morgan from page 1 to 31 of my case law. Second one is the British impeachment trial again of Hastings and that period of 14th century by Professor Frank Bowman, pages 32 to 79. The other article is by Professor Michael Gerard, pages 80 to 103. The other article is High Crimes Without Law, page 104 to 122 by Professor Nicholas Bowie. These articles, my Lord, are by the most eminent professors of impeachment law. All these are professors at Harvard University, Yale University, Georgetown University. They are professors of that part of the law without basically competition, my Lord, and we must defer to their scholarly writings. And my Lord, if you look at those articles, it basically tells us that impeachment are criminal processes to deal with excesses of the executive. And I've highlighted the various sections, and I'm not going to go through them, but all of them are agreeing that it is to deal with excesses of the executive, basically of the president and the king and the advisors close to the president and the king. And of course it defines again, my Lord, the crimes, the offenses that fall under impeachment proceedings, which include, of course, treason, armed rebellion, corruption, incompetence, neglect of duty, maladministration, abuse of power, betrayal of the state, and common criminality. My Lord, our impeachment process in this country, again, is in my submission, at part G of my submissions, is set out in the standing orders, articles 219, 220, 223, 230, and 230 of the National Assembly standing orders, which have annexed from page 123 to 131. Again, it sets out in the standing orders the process of setting in motion impeachment proceedings. And one of them, my Lord, is that once you file a petition, there is no room for alteration. The petition remains as it was filed and it never changes. It is not what has happened, what has happened before you. The petition before you is not what was presented in the National Assembly by the four petitioners. My Lord, impeachment under Article 251 is sui generis, is of its kind. There's been a confusion by the lead counsel to confuse impeachment of under Article 251 with the removal of DPP, which is 158, removal of judges, which is 168, and removal of governors, which are 181. Removal of DPP, judges, and governors, they have been given effect by statutes. They have statutes that give effect to the implementation. Article 251, my Lord, does not have a statute, and is not by mistake. Impeachment proceedings all over the world, in England, in America, South Africa, all those countries, there is no impeachment statute, and it's because for a reason. Impeachment is a political process, and you cannot enact a political process that keeps changing every time. No country has enacted a statute on impeachment for a good reason. My Lord, again, I've set out in the supporting articles, relating those articles. My Lord, the accusation against Commissioner Irene Masit and the other 3 Commissioners, Charara 4 basically, is that they tried to subvert the election results of August 15. So, my Lord, let's take a pause and understand what happened on August 15, or the law relating to August 15. And in my submissions, I've called it the presidential elections pathway. My Lord, how election results are declared is set out in Article 138 of the Constitution, Section 39 of the Elections Act, and the Gazette Notice number 9540 that was published by IEBC.